this is Celia Lacayo again, Associate Director of Community Engagement with the UCLA College of Letters and Sciences, and also a professor in the African American Studies and Chicano Studies Department. Today we have Professor of Law in the UCLA School of Law, Jennifer Chacón, with us today to talk to us about immigration, court cases and laws, and how these are being affected during COVID-19. Hi, Jennifer. Nice to have you with us today.
Thank you so much. I'm really happy to be here.
So can you tell us, you and your co-author wrote an excellent piece, op-ed piece in the NYTimes, where you spoke about some of these things. Can you tell us how would an immigration freeze affect public health?
The president issued a proclamation on April 22nd, 2020, that froze a significant portion of lawful immigration into the United States. And you asked what impact that will have on public health. And one of the interesting things about that presidential proclamation is that it doesn't bear any relationship to public health at all. The president didn't attempt to justify the freeze on public health grounds. The proclamation doesn't suggest that it is in any way necessary to address a public health threat. So the proclamation in question creates an immigration freeze to address economic concerns. The president notes that there is a widespread economic harm that's been caused by COVID-19 and the related shutdowns. And he notes that the economy may be slow in recovery and that this will have an impact on various populations. And so in response to that, he suggests a ban on lawful immigration is necessary. And as you noted, my co-author Erwin Chemerinsky and I wrote an op-ed in the NYTimes the day the presidential proclamation was issued, really contesting the legality of the president's proclamation. And our concern was really that this proclamation is not something that the president is empowered to issue. So you might recall the president's efforts to control immigration through other previous presidential proclamations and executive orders. The most notable was the effort on the part of the president to limit immigration from certain predominantly Muslim countries, something that the president referred to repeatedly in campaigning and afterward as the Muslim ban. And after various modifications, the proclamation was challenged in court, and ultimately the Supreme Court decided that the president did have the authority to limit the entry of certain individuals from predominantly Muslim countries because the president and the Department of Homeland Security cited to national security concerns about the admissions process with regard to individuals entering from those countries. With this presidential proclamation issued on April 22nd, the president attempted to rely on the same powers that he relied on in freezing immigration from predominantly Muslim countries, that is the Immigration and Nationality Act, Section 212F. Now, the problem with that, of course, is that Section 212F really contemplates the president responding to a national security emergency. I actually think that the Supreme Court interpreted that provision excessively broadly in Hawaii versus Trump when it decided that President Trump had the power to bar individuals immigrating from the named countries in the Muslim ban proclamation. But even if you accept that the powers of 212F are as broad as the court contemplated that they were in that case, they don't reach as broadly as to allow the president to disrupt the congressional scheme of immigration for reasons outside of national security concerns. And that's exactly where we are with this proclamation. So the president says that he's responding to an economic threat and barring people from coming in potentially to compete with jobs against American workers. And the problem with that is that there's no evidence that the barred immigrants are actually competing with American workers for jobs. The congressional scheme in the immigration code already contemplates concerns about American workers and balances the interests of American workers against the interest of individuals seeking to reunify with immigrants outside the United States, whether they be employers or family members here in the US. So Congress did that calculation in the statute and made a determination about which categories of people should be admitted into the country. And the president has upended that with this order and has tried to rely on a provision that is not designed to allow him to upend the entire statutory scheme in order to achieve his own policy goals. This is a situation where the president has done an end run around Congress. If Congress wanted to, they too could modify the immigration law. They could change the criteria for legal immigration. They could impose limits on the number of green cards that were issued to people seeking employment in the United States. Congress absolutely has the power to do that under the Constitution, but the president doesn't have the power to unilaterally decide that he doesn't like the balance that Congress struck and that he's going to change it. And that's what happened here. We see an end run around Congress and not in response to any national health emergency, not in response to any national security emergency, but in response to economic concerns that Congress has already balanced and that Congress is entitled to rebalance, but that the president can't unilaterally change. So who is affected by this unlawful ban? Well, as I indicated, it's people who are coming in order to become lawful permanent residents, people who would have the possibility of naturalizing and becoming U.S. citizens. This is a relatively small percentage of the people who come into the United States every year. The vast, vast majority of people coming into the United States on any given year come on non-immigrant visas. They come to fill temporary employment needs, often working for foreign employers. They come as students, they come as tourists. This is the vast majority of flow across borders, and that's unaffected by the ban. The ban really strikes at the heart of lawful immigration. It is designed to affect the long-term immigrants who are seeking to enter. And the ban actually carved out some categories of green card recipients. So it carved out people who were coming to reunify with a parent if they were a child of a United States citizen under the age of 21. And it carved out spouses of U.S. citizens. And it carved out essential workers to be determined discretionarily by consular officials. But it essentially allows for a bar on anybody else. This could include older children of U.S. citizens. It can include the children and spouses of lawful permanent residents. It can include individuals who are coming to work for particular employers to meet certain needs. And so all of those people are banned. And this is really the heart of the legal immigration system. It is something that Congress designed and something that the president has upended.
Thank you, Jennifer, for that wonderful comprehensive understanding of what the immigration ban is for people to really understand its multiple components. Can you please tell us more specifically the effects on jobs, the economy, and public health?
So first, with regard to the ban we've just been talking about, we can see that it was not a response to a public health crisis, although there is a public health crisis ongoing, and it's unlikely to have any ameliorative effect on the ongoing public health crisis. It was framed as a response to an economic crisis, but it is not responsive to that economic crisis. It's not going to generate U.S. jobs. It's not going to generate new opportunities for the millions of displaced U.S. workers. What it will do is it will complicate the lives of people who have been waiting for a very long time, often for years, in order to receive their visas, to unify with family members, and to come to the United States. And so the biggest effect of the ban will be its disruptive impact on a relatively small handful of people, but a vulnerable handful of people who have been waiting for a very long time to take advantage of the nation's legal immigration system. So it has no significant upside, but it will have the downside of a substantial disruptive effect on some people who have been waiting a long time to benefit from the U.S. immigration system. If we think about other responses by the administration to the public health crisis in the immigration sphere, one thing that obviously jumps out is the use of quarantining and travel restrictions on people traveling to the United States from China and then later from Europe. And the administration used those as an effort to contain international spread of the virus. What we know now is that, first of all, these attempts were quite belated, that the administration failed to act on public health information that might have made those quarantining efforts more effective. And we also know that because of the way they were implemented, they might have actually increased public health harms. We've read recently about the fact that the threat of a European travel ban prompted some people to travel sick in order to beat the ban, and the result was that many sick travelers probably infected many other travelers in airports and on airplanes in trying to evade the ban. So they were not rolled out in a way that was particularly well designed to achieve public health ends either. The other place we might look as a site of an immigration response to the public health threat is to the southern border, where the administration has used immigration law as a way of purportedly responding to a public health threat, but in fact as a means of furthering its own interest in shutting down asylum at the southern border. For months now, the administration has really put a damper on the ability of individuals to process their asylum claims at the southern border. Long before the virus, the administration enacted a policy which it calls the Migrant Protection Protocol, which in fact doesn't protect migrants, but does require them to wait outside of the United States while their asylum claims are processed. So this has resulted in the presence of tens of thousands of asylum seekers who are waiting along the U.S.-Mexico border in places like Tijuana and and Juarez, in trying to access immigration courts to have their asylum claims processed. And these encampments of individuals who are trying to have their asylum claims processed have become themselves potential sites of infection and public health risk for people who are placed in that dangerous and untenable condition. So that's a problem. Rather than seeking to alleviate that problem in the face of COVID-19, the administration has simply chosen to abandon asylum seekers at the southern border. So the asylum process is essentially frozen. Individuals who come to the border now seeking asylum aren't even put in the Remain in Mexico program. They aren't even sort of put in a line to process an asylum claim. They're being summarily sent back. And this includes individuals who are under the statutes of the United States subject to protection, people like minor children. And the administration has taken the COVID-19 crisis as an opportunity to disregard its obligations under international law and domestic law to process asylum seekers, to protect vulnerable youth, and instead is just turning those people away at the border. This doesn't solve the health problem either. It's not responding to COVID-19. If it were responsive to COVID-19, then presumably it would involve individual health screenings to make sure that individuals who were infected were not coming in and spreading the disease. It could involve quarantining. It could involve a whole host of appropriate public health measuring and responses. But what happened instead is just a complete abdication of U.S. responsibility to provide an adequate forum for asylum seekers. So people are being sent back from the border on the basis of a CDC guideline that was issued pursuant to an age-old quarantine statute, one that predates the asylum laws of the United States. And on that basis, the administration is using the public health risk in order to do an end run around asylum law.
Wonderful, Jennifer. You had some final thoughts. Can you, in closing, share those with us? Thank you.
So the administration's response to asylum seekers at the southern border suggests that the public health risks are so pronounced that we can't even comply with our international obligations to provide a forum for asylum seekers to process their claims. And yet at the same time, the administration continues to detain in civil detention tens of thousands of immigrants in unsafe conditions where they're at close quarters, where they are subject to community spread, and they are not releasing people from immigration detention in any significant numbers. So for those who don't know, the United States has an immigration detention system which it uses in order to detain people pending their immigration hearings. This is not a form of criminal detention. It's not a punishment for some crime that individuals have committed. Individuals who are in civil immigration detention are there solely because they are being held while their immigration claims are processed. There is no requirement in these cases that individuals should be shown to be a danger to the community or a flight risk in order to be detained. In many cases, the statute simply mandates detention without a requirement of either of those showings. So the vast majority of people in immigration detention pose no risk to the community and pose no flight risk. They are not serving punitive detention. They're waiting for their hearings. And it would seem if there was ever a moment to take seriously a public health risk, it's now. And if there was ever a place that presents a public health risk, it's these immigration detention facilities. So these are individuals who should be being released in large numbers if we are serious about combating the spread of COVID-19. It poses a risk to immigrants in detention. It poses a risk to everybody who works in detention centers and those who come in contact with them. But that is not the tack that the administration has taken. So individuals remain in immigration detention. And what we have seen is a number of legal actions, including the filings of petitions for writs of habeas corpus, seeking for federal court intervention in order to allow for the release of some detainees with underlying conditions that make them particularly vulnerable to COVID-19. So there's been some success on that front for the release of a limited number of detainees. But by and large, we continue to have a sprawling immigration detention system filled with people who remain quite vulnerable to the spread of the virus. The second kind of closing thought I have with regard to the immigration response around COVID-19 relates to deferred action for childhood arrivals, which seems a little bit unrelated at first. So you might remember that President Obama and his administration created a program called Deferred Action for Childhood Arrivals, which was announced in June of 2012, and which allowed for individuals who met a certain criteria to be deprioritized for removal, to gain access to work authorization, and essentially to be allowed to work and remain in the United States without being a high priority for deportation. Those individuals were able to renew their deferred action status every 2 years through an application and fee. And that program was the Obama administration's stopgap measure as they hoped that Congress would pass legislation that gave these individuals more permanent relief. Congress to date has failed to act in this regard, and so deferred action is the only protection that these individuals have from removal, and their employment authorization hinges on their deferred action status. In November of 2017, President Trump attempted to rescind deferred action for childhood arrivals. His administration, through Acting Secretary of Homeland Security Elaine Dukes, announced that they would no longer grant deferred action applications. They were going to allow renewals to be processed for a limited period of time, and then individuals' DACA status would expire. There were a number of lawsuits in response to the rescission, and so at the moment, the rescission is frozen. The DACA program continues to exist for individuals who had already received DACA. They can continue to renew. But the Supreme Court heard the case this fall and will decide whether the president's rescission of deferred action is legal or not. And that's relevant in this context because, as we saw in a filing from a number of immigrant serving organizations in the Yale Law School Clinic, there are literally tens of thousands of deferred action recipients who work in the healthcare sector. And the only reason they can work in the healthcare sector under the current legal regime is because they're granted work authorization pursuant to DACA. So if the Supreme Court were to decide that the rescission was lawful and goes into effect in short order, then there are a lot of healthcare workers who will no longer be able to work lawfully in the United States and will be faced with the potential for removal, despite the fact that the vast majority of them have spent the majority of their lives in the United States. So that's another thing to watch as the Supreme Court is on the cusp of deciding the deferred action for childhood arrival case.
So we can see that these are really, again, vital issues that are affecting our city, county, and our society. And we had here today a legal expert, professor in the law school, Jennifer Chacón. Thank you so much. We really appreciate your expertise for us to really understand what is happening in immigration amidst COVID-19. Once again, I want to say thank you so much. And when the Supreme Court has its decision on DACA, hopefully we can have you back.
Thank you so much. It's been great to be here.